Our top story tonight is the most consequential test on the power of the presidency since Donald Trump assumed office. And this is a test he narrowly passed. Today, the Supreme Court upheld the revised version of Trump's travel ban. Now, whether you agree with that decision or not, it's a reminder that for all of this president's hyperbole and attacks on the rule of law, it is the law that has the final word tonight, not Donald Trump, just as it was the law that narrowed his original travel ban after those first days of total airport chaos. And in a tradition familiar to many presidents who wait to see if the Supreme Court will let them use their powers or if it will narrow their powers, Trump celebrated today's ruling.
A tremendous success, a tremendous victory for the American people and for our Constitution. This is a great victory for our Constitution. We have to be tough, and we have to be safe, and we have to be secure. The ruling shows that all of the attacks from the media and the Democrat politicians are wrong, and they turned out to be very wrong.
The Supreme Court did not rule on whether this travel ban makes America more secure. Many experts say the opposite, but that was not the question before the court today. The question was quite narrow. Does the Constitution give a president the power to bar immigrants from certain countries? And did the final version of the travel ban do that or operate as a religious test? If you follow this issue, you may have heard many other questions like, is this fair? Is it right? Is it good for security? And those are certainly important questions for the political branches, for the voters. But the Supreme Court is not supposed to resolve those questions for us. That's the way it's always been, which means Trump was always more likely to have this ban upheld. And whether you think that's good or bad, that's always been the legal framework, because we know the courts give presidents a lot of latitude on immigration. Back on the first day after Trump ordered the original travel ban, amidst that airport chaos and those protests, I was out reporting on the whole mess, but also on the legal framework. I explained at the time that ban was likely to be upheld because the courts could interpret it as something less than the religious ban that Trump originally campaigned on.
Is it likely to be upheld? Probably. We can say that there is great executive authority in the area of immigration. Is it written as a religious ban the way Donald Trump campaigned on? No, not at all.
Today, the Chief Justice of the Supreme Court wrote a majority opinion ruling that this ban has legitimate purposes and says, quote, nothing about religion. Also noting the issue before the court's not whether to denounce things Trump said that critics believe strike at fundamental standards of respect and tolerance. By the standards of the Supreme Court here, that is an important line. Think about it like this. Tonight, the court upholds the president's constitutional authority, but also notes that critics say this president is an affront to the very tolerance America needs right now. In fact, if you put aside a lot of the hyperbole and read this opinion, it cites President Eisenhower's defense of Muslim Americans' rights to pray, and then it shouts out George W. Bush for visiting the same Islamic center that Eisenhower visited to bring his message of tolerance for Muslims after 9/11. Quite a contrast to today's Donald Trump. Now, the court obviously isn't citing that history at random today. It is a sobering moral contrast to this president. But when judges are restrained, they don't weave their moral calls into the rulings themselves. And thus, Justice Roberts writes a key phrase today that captures much of this era. Quote, we must consider not only the statements of a particular president, but also the authority of the presidency itself. The statements of this particular president are different for the reasons we all know, because they're divisive, they're often ugly. Sometimes they're even blatantly unlawful, like that campaign pledge he made of a plan to violate the Constitution.
Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what the hell is going on.
Against this backdrop, today the court also took an extraordinarily unusual step, using this majority decision that agrees with Trump to also state its view on a totally unrelated historical case that, think about this, until today remained a shameful precedent on the books in American court history, because the Supreme Court infamously upheld the legality of Japanese internment, a precedent that's been discussed a lot lately, given Trump's internment and separation of immigrant families. Today, in response to critiques from dissenters about the travel ban decision, the conservative majority on this court, given the current climate, writes this: the old decision upholding internment was gravely wrong the day it was decided and has no place in law under the Constitution. So there is much important substance in this decision, whether one agrees with the result or not. The political reaction to the case has been fierce. The first Muslim elected to Congress, Keith Ellison, hammering the electoral side today that the Supreme Court seat stolen from Obama before the election paved the way for this ruling.
This decision was set as soon as Neil Gorsuch was seated in the court. It is not really a decision based on what the facts are. It's based on the composition and the political ideology of the Supreme Court at this moment.
That is broadly true. The court reflects its appointees, who then reflect, at least to some degree, the party that controls the White House. And we do know Senate Republicans broke a precedent by flatly refusing Obama's nominee to the court in 2016. But if you play what if, eventually it cancels everything out. If Trump didn't win, then Gorsuch wouldn't be on the court, but also there wouldn't be a travel ban to rule on today. The larger point goes a little deeper tonight. Courts are still, with everything going on right now, they are still a guardrail for the Constitution. That's a good thing. But they're not there to overrule any old bad idea that people may want out of the political arena. The Constitution gives the president broad immigration power. And as the nation now assesses the competence and the ethics of Donald Trump's use of that broad power, the question is not whether Donald Trump has it, but whether, as a nation, we want him to continue using it like this. I'm joined by a special guest for this discussion. Anthony Romero is the executive director of the ACLU. He's led the charge on the ACLU's lawsuit against this travel ban, and a Legal Eagle legend, NPR correspondent Nina Totenberg. Mr. Romero, what do you say to the fact that you lost because the Supreme Court determined that in its narrowed form, this was not technically a ban on Muslims or a religious test?
It's a tragic day. It's a tragic day for the Supreme Court. It's a tragic day for the country. And when I read the opinion twice today, especially the majority opinion and then the dissent from Justice Sotomayor, I was struck about how we had two competing worldviews. I mean, the majority opinion tried so very hard to give him every benefit of the doubt and gave him great deference, as you cited in the opening segment. It skirted over the questions of the animus, which we believe really was at the heart of this third proclamation. And ultimately, I believe, and my colleagues at the ACLU and I believe, that they applied the wrong standard in deciding this case. And so they set the bar incredibly low for the government that they could easily hurdle over. At the end of the day, I think this case will go down in history.
Saying, just to be clear, Anthony, you're saying that they basically put the fix in by using a rational basis standard, which almost anything would pass, rather than something stricter because of the anti-Muslim statements the president made?
And it's relegated to a small footnote on page 32 of Roberts' opinion. But when you read Justice Sotomayor's opinion, where she talks about how they discarded precedent in dealing with the Establishment Clause, the reasonable person standard, the reasonable observer standard is what should have governed, and that they rigged the outcome of this ruling by using the rational basis standard. And then she talks about how they gave complete short shrift to the long history of the animus that led up prior to the first and second and third executive orders, the comments he made as president. I mean, they're cited in Justice Roberts' opinion because he's smart enough to put some reference to it. But he gives it really short shrift. And there was a line, especially in Justice Sotomayor's opinion, which I found so telling. Deference is different from unquestioning deference, or acceptance, rather. And the idea that we can be deferential to the executive branch, but it's not anathema to question the executive branch. And she really does walk them through the whole process of how they missed an opportunity to delve into the facts of this case. It's a missed opportunity. And it will go down in history. They repealed or they overruled Korematsu, and they put another Korematsu on the books.
Nina?
Well, I think it's fair to say that this decision does give the president, this president and any president, more power than they had before. That there are, for all practical purposes, almost no bars that have to be crossed, that are too difficult to cross. If all you have to do is show that there is arguably a connection to national security, almost anybody can make that argument. And in some ways, the Trump administration is lucky that the first two versions of this got struck down by the lower courts, because it's not entirely clear to me what the court would have done if it had gotten one of the earlier ones that had very little to back it up. They even were, for example, barring legal permanent residents in the United States from returning here if they were abroad and they were coming back, they were barred. They forgot to put that in. That's how crazy the first one was.
That's right.
So in some senses, by the time they got around to the third one, they had jumped through all the hoops. They actually did an administrative review. They crossed the T's and dotted the I's. And what the Chief Justice said is, we actually don't dispute any of the comments that the president made about Muslims and whether they display a bias towards Muslims. The fact is that we're not even looking at that. We're only looking at what is in this third version, which has neutral words on its face and therefore passes muster. But you know, you can make the argument, and some people I talked to today did, and some of them were from previous Republican administrations and national security positions. One of them said, this is still a pig. They put the lipstick on it. They dressed it up so that 5 out of 9 people accepted it, but it's still a pig. And, you know, you can make the argument
that raises the question, Nina, it raises the question, is it a blind pig if it won't look at what the president said and did?
Well, I think that the court made pretty clear, and it always makes pretty clear, that it really doesn't want to get involved in national security questions. This isn't like kids at the border. That's really a different question. This is a question that the president linked to national security. And over again over the years, the court is very hesitant to get involved in these questions. And even in the Guantanamo cases, it took them 6 years to finally realize that if they didn't set down some standards, there weren't going to be any for how these people were treated and how their trials were to go forward, and et cetera. And I think for a while this chapter is closed, but there is a tiny little place. There are a couple of nooks and crannies where, after a couple of years, it's conceivable that litigation could put a lot of pressure on the Trump administration, for example, to grant many more waivers of the ban, and to let people come here when they have medical problems, when they have a job,
which is
when they have scholarly endeavors, et cetera.
Right. Which is partly what Justice Breyer was getting at in his dissent, of saying, well, how much can you hide behind exceptions if they aren't really meaningful, and why didn't we do fact-finding on that? And so I think the crosstalk, you know, between the majority and minority there was rich. I want you both to stay with me for a perspective from a Trump supporter. I want to bring in Republican Congressman Bill Johnson, who is happy with the decision. Sir, why is this good for America in your view tonight?
Well, I think, first of all, let me say, Ari, that I respect our panel members today. Nina, I have followed your work for a long time. Anthony, I've watched your work from the sidelines as well. And I think all of you make some points, some of them good. Obviously, it's not a secret. Some of them I disagree with. What the court did today was essentially, Ari, what you said in your initial comments. They ruled on the constitutionality of the Trump administration's actions, the rule of law. That's why I believe it is a victory for America, because it stands on the Constitution and it stands on the rule of law. And I think that's what is so vitally important. What the Supreme Court said today is that the President of the United States, who is solely charged with the defense, the protection and defense of American people, charged with executing policies to protect our national security, it is the chief executive who has the authority to make these kinds of decisions, not the courts, not outsiders.
Right, and I think you're alluding to a point that Nina was making earlier in other case law, which is even in very controversial situations, we do know the court, or at least a block of the court, doesn't like to second-guess potential national security decisions in real time. Anthony and other critics have... Go ahead.
Lower courts have made this decision before also. I mean, if you look back at Shaughnessy versus Harisides, a federal judge said that a federal court should not even hear a case related to determining whether or not the chief executive can make or decide who comes into our country and who doesn't come into our country. And you know, we can argue the points about rhetoric and what was said, but what we have to base this on is what was actually done, because there's only a few Muslim countries that are included in this ban, less than 10%.
Let me do one thing on this for you first and then the panel, which is this other thing that happened tonight that's so unusual. The Supreme Court using today's decision to deal with Japanese internment. I think we would all agree that's an unusual thing to occur in the middle of this kind of decision. Congressman, for you first, take a listen to Donald Trump doing what his lawyers would surely advise against, which was citing that disfavored precedent on this issue.
What I'm doing is no different than what FDR's solution for Germans, Italians, Japanese, you know, many years ago.
So you're for internment camps?
This is a president who was highly respected by all. He did the same thing. If you look at what he was doing, it was far worse.
He did the same thing, Congressman. That was a candidate Trump's defense. For you and then the panel, your view of the news tonight, is it good the Supreme Court has emphatically and finally said that Japanese internment decision was wrong? And if so, was Donald Trump wrong to invoke it?
Well, I can't speak for the president, and I have not read the full report or the full ruling from the Supreme Court. I do agree with you that it's very unusual that they would go back that far and bring something up like this. I think I'll have to stand on my earlier comments that what makes this such a landmark decision is that the Supreme Court said that it is the chief executive under our Constitution, under our system of government. Our president has the sole authority to make these kinds of decisions based on America's vital interest and national security. I think that's the important takeaway here.
Well, you know.
Yes, sir. Let me go Nina and then Anthony.
Well, if you look at this decision by the Chief Justice, obviously the Japanese internment was added on the last page because the dissent, Justice Sotomayor's dissent, said this is analogous to the Japanese internment. And that clearly jerked his cord big time. Because, you know, you can't find a serious scholar in the United States of America who would defend the Japanese internment or slavery anymore, or Dred Scott. And he didn't like at all being lumped into that group. And so he made very clear, that's why he reached back and said it was wrong the day it was decided. It's wrong now. We're taking this opportunity to wipe it off the books. It is no longer operative precedent.
Absolutely right, Dina. And I think, with all due respect, sir, although reasonable people might differ about this opinion, no one can differ about what the legacy was of Korematsu, in that case in 1941, brought by the ACLU and lost in 1944 at the Supreme Court. And the fact that the Justice Roberts bent over backwards to have to reference it because he must have seen it in the draft of the dissent that was coming to him as he was writing his majority opinion. And also the insertion of some nominal talk of the religious animus in the majority opinion also speaks about how he had to respond to the dissent. I think ultimately the one opinion that I find the most curious is the tormented opinion by Justice Kennedy, 1.5 pages.
And you can't tell what it says.
He talks about how we can't review this action by the president, but then he goes on to scold the president, in my view, as I read it between the lines, about how we need civility, how elected officials need to uphold the Constitution. And it's a man who's obviously tormented by the fact that he's voting with the majority because he has a very limited view of what judicial review is in this context. But he obviously is having very great difficulties on the statements and even the policy outcomes of the president. And with all due respect, I think this is one of those moments when I think Justice Kennedy might regret that opinion, that he didn't go the extra yard to bring the ball across the goal line. All
Of course,
eyes
he
were on
might-
Justice
you
Kennedy.
can't tell what would happen in the future. He changed his mind about Guantanamo.
Exactly.
And that's what happened in those 6 years. And I thought that page-and-a-half opinion was a little bit of a warning shot, as was, in some ways, the Chief Justice's opinion talking about the responsibility of a president and refusing to, in any way, try to mitigate President Trump's statements expressing an anti-Muslim bias, just saying that's
Right.
not our business. If Congress wants to change it, it should change it, but not, he's nowhere defending those comments.
Well, and
Right. And I have a
don't know,
warning shot as well, which is I have to fit in a break. Congressman, briefly, final word.
Well, I was going to say you can't just take a few things that the president said. You have to look at the context of all that he did. He did not include all Muslim countries. There's less than 10%, and 2 of the current countries are not even Muslim countries.
Window
so,
dressing.
and with the waivers and the waivers for asylum, I think
Window
you have to look
dressing.
at the total context.
Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.